In the last class, we have seen about arbitration agreement, and in regards to that, I have sent you several agreements that are required in the arbitration. As we have discussed in the last class itself, that in the process of arbitration, we require arbitration agreement. That is the first and foremost thing that we have discussed in the last class. Now, after this arbitration agreement, in the last class itself, we have uh, arbitral. Now, institution of arbitration. So, in the today's class, I'll give you a brief idea about how this arbitration actually works, how this arbitration, and apart from that, I'll give you an idea that in what cases, in what scenario will you apply the, idea mechanism of arbitration and conciliation, right? So this class will be one short class where you will see entire, methodology working and making you efficient enough with the knowledge so as to apply this principle concept in the practical scenario. Right. So first of all, we'll talk about Section 8, which is very important. Section 8 talks about what kind of cases actually goes for arbitration. It is the power of parties to refer the case for the arbitration. So what kind of cases that actually goes for arbitration? Right? Arbitration is purely commercial matter. First thing, right? So there are two kinds of arbitration here. You'll see domestic arbitration and international arbitration, international commercial arbitration. Right. Now, domestic arbitration is arbitration where both the parties, obviously, in arbitration, there can be only two parties, right? So, in domestic arbitration, both the parties, party A and party B, both are from India itself or the nation. I mean, if you're talking about any other country other than India, so that those two individuals will be from a specific country, right? One country. That would be domestic arbitration. Now, the concept of domestic arbitration is for resolution of the dispute for domestic matter and application of domestic laws. Right. When you talk about international arbitration, you see that let's say I am from India and the other one, let's say Elizabeth is from UK. Now there are two individuals governing under two different laws. Is it or is it not? Two individuals governing under two individual laws. Now, idea here is that when you are drafting an arbitration agreement, always subject your place or seat of arbitration to the jurisdiction or to the place where you want your laws to be involved. Let's say I don't want Indian laws to be involved in my contract. I want UK laws to be or England, law of England to be involved in this arbitration. So I'll choose England or Wales or any other country that is there in UK to be a place of arbitration and seat of arbitration. It, that will itself decide that which law is going to be active or through which law will be going through resolution. For the kind matter, for the subjective matter, we should know that Arbitration and Conciliation Act in India was enacted in 1996, right? And there are two conventions governing this arbitration agreement. One which is active, Geneva Convention, the old convention. One which is active is New York Convention. Now, New York Convention is active for all the countries, whosoever is member of even, right? And whosoever has signed New York Convention. More than 200 countries have signed New York Convention. So this this New York Convention is active for all the countries, which means that whatever you are reading in India about arbitration, particularly, I'm not talking about mediation, I'm not talking about any other law, I'm talking about arbitration. So whatever you are reading in India is applicable in UK, US, Singapore, name the country, it is applicable. If it is the member of WTO, if it is the member of United Nation, right? So these laws are applicable to them as well. Moreover, like there are some countries who is not signatory to New York Convention. Those are in exception. You can find it on that the country who is signatory to New York Convention under arbitration and country who are not signatory to New York Convention under arbitration. You will get it on the internet. I'm making a general statement so that it is easy for you to understand. Right now, back to arbitration, where we are discussing about how we'll place our arbitration agreement into the jurisdiction of a country and when to do that. Right, when to do that. First of all, when you want to apply the concept or when you want to apply the law of a particular country, let's say I'm living in India, right? And Entire arbitration will also be done in India. Right? Now I want Singapore laws to be applicable over here. In civil matters that cannot be done. If the place of dispute is in India, then only Indian laws will be applicable if the matter is not related to consulate. Only India's laws will be applicable. Now, in the case of arbitration, even if the entire matter is landed in India, and one of the country, sorry, one of the party is a citizen of Switzerland, you can have any place in Switzerland as a place of or seat of arbitration, and the law of Switzerland will be applicable in our contract, in our resolution of dispute. And the first appeal, or the first court that will visit is district court of Singapore, Switzerland, sorry, right? So that is how entire paradox of arbitration will change just by changing the name of or the seat of arbitration. Now, as we were discussing section 8, in section 8, we have seen that what matter can be referred to arbitration. We were discussing that the only commercial matter can be the subject matter of arbitration, saying that family matter are not subject of arbitration. All the criminal matter, whether it is cognizable, whether it is not cognizable, doesn't matter. If that is the criminal matter, and you are looking for penalties, if you are looking for compensation, so compensation and penalties are not the matter of arbitration. Right. However, I'm saying about fine. Sorry, fine and penalties are not the matter of arbitration. Compensation, obviously, 2% or 5% or whatever you have decided will be is the commercial matter only, and that will be the subject matter of arbitration. Okay. Now you see that, sir, in some cases, in family dispute, in the matter of divorce also, court asks for mediation. So it is also important to differentiate between mediation, conciliation, arbitration, and what you call it, Lok Adalat, right? And simultaneously, litigation that we practice in the court. So there are, I'll say, if, even if a small difference there is, this is small difference in a longer run or in a practical scenario becomes entirely a different domain. Like in arbitration, you will have a private judge. The judge that you call in, district court or criminal court, in arbitration, you will call them arbitrator, right? You will call them arbitrator. Now, you won't be calling them just because they are not in the permanent position. They are not taking salary of from the taxpayer from us. Right? This arbitrator will be paid from the pockets of party only. Do you think that in the regular litigation you pay to the judges? That will be that will be a content of the court if you pay to the judges, right? Am I right? If you start paying to the judges for their service that they're doing, that would be content of the court, because providing judgment, providing justice is a sovereign affair. You cannot pay the government for providing a sovereign affair, right? Sovereign is you, and they're doing that for you. Now, in the case of arbitration, you see that there are two parties, and these two parties combined will pay the cost of entire arbitration, including litigation, including arbitrator, including the police, and maintenance and everything. They are going to take it up. Idea, I mean, you must be getting an idea how different is arbitration from litigation, and how different it is from now. Mediation and arbitration is very important. They're very close. Now, in mediation, until and unless we have this mediation Act 2023 into picture, that is, passed by Parliament in 2023, November 2023 itself, but the same has not come into effect. Which means that currently the law for mediation is same as that were these before, right? So arbitration is the matter where if arbitral award will pass by arbitral award will pass by arbitrator, that will become binding. Mention this word, note this word, that whatever arbitral award will pass by arbitrator will become binding. Not this the award ipso facto doesn't become binding when it is passed by whom? Mediator. Do you get it? Are you getting the concept here?
Yes, sir.
right? So if the mediator passes any award, so what good is the award that is passed by mediator? Why we are referring the case to mediator? Right? There is settlement agreement. When you practice mediation between two parties, you will have to draft settlement agreement. Right? So settlement agreement, I think that I have that format. There is no generic format for settlement agreement, but when we do that in practice, we always take certain scenarios or certain drafts that can help us. But per se, there is no ideal draft for this settlement agreement. However, see, I can or anyone can be a mediator, and two parties who are in dispute, if I have that experience of making the settlement, I can have bargaining among them. I can negotiate between them, and based on the bargain, based on the negotiation, party will reach to a common consensus. When the party will reach to common consensus, we draft that consensus into an agreement, and that agreement will be signed by both the parties. Now, even after signing the agreement, the settlement agreement is not binding. Right? Even after signing this, it's not binding. It will become binding when the party will go to the court and ask the court to, ask the court to make the order or decree based on this agreement. Do you get it now? There is one more process when we talk about mediation. In arbitration, what it was happening that when the arbitrator when the arbitrator passed the award, it automatically become binding. And to repudiate this, you need to go to the court, right? To remove this or to repudiate it, you need to go to the court, district court, so as to set aside the arbitral award under section 34, right? Now, when you are signing an arbitration agreement, when the party is signing an arbitration agreement, what is happening here is that it is not becoming binding, is perfecto automatically by itself, right? You need to go to the court and ask the court, request the court to pass the award based on this agreement. And you know that you cannot command the court. No one in this nation can command the court. Court will see to the merit, and court will judge based on the circumstances that whether this is under undue influence, mistake, fraud, misrepresentation, right? Whether this settlement agreement has reached based on all of this ingredient or not. If this is not based on undue influence, mistake, fraud, so and so, then the court will pass an award. And if that is up to the merit, and if that is up to the merit, then the court will pass an award, and that award will become binding and will be executed by executing court and not the party itself. Now, do you get the huge difference here? Are you able to comprehend? Are you able to make up your mind that in what cases would you refer a party to arbitration? In what cases would you refer a party to mediation?
Yes, sir.
Yes, sir.
Right? Now, when a court says that in particular case, let's say domestic violence, or let's say domestic violence is the matter of criminal law, so that goes to entirely different domain. Let's say talk about maintenance. Let's talk about divorce. These two are still a civil in nature. Okay? Maintenance has a criminal nature as well under section 125 CRPC. I don't know about BNSS, but the same. We're not talking about maintenance in the 125. We're talking about maintenance under section 20, 24, 25 of Hindu Marriage Act, and section 18 to 25 of Hindu this Hindu Majority Act, right? So here you see that when you talk about divorce, when you talk about maintenance, these are civil in nature, and you can go for mediation as we have discussed, and then the party will go to the court where the case was pending, and based on merit of the case, the court will declare an award that will become binding binding later on. Now, what is conciliation? Conciliation is also a process that's very important because on a regular basis, or if you are practicing in, let's say, labor law, labor court, or you are visiting, because most of us are accustomed to labor law, because on a daily basis we don't come ahead or don't get into we're not in touch with the big companies, because arbitration is the matter of big companies and MNCs and all. Right? However, labor dispute are the regular matter that we keep on discussing, that keep on coming in our court, in our chamber, and there we see that this in conciliation again they'll be considered, like in mediator there is mediator, like in arbitration there is arbitrator. Likewise, in conciliation they'll be considered. Role of all these guys are the same to resolve the dispute. Now, what is happening that in the arbitration, arbitrator is the one who is signing the award under section 31. In conciliation, parties will be one who will be signing the award, because the case is not been discussed on merit. The prime nature of the mediation or of the conciliation is to resolve the dispute between employer and the employer, or between the employees. Right? Here, in the same workplace, no one can be winner. Let's say in a case where the employee is winner and the employer is at the losing side, employer always has the benefit of terminating the employee. Right? So actually, employee cannot win. I mean, obviously there can win. Obviously there are scenarios, but we're not talking into those aspects. We're talking generally. So generally, employer has, because they are the one who have given you the task. They are the one who have given you money, giving you money, salary. However, there is good governance. There is law. There is law to everything. But again, if you're talking to practical scenario, there is no law which can stop an employer to fire one or two employees. Right? If not the mass resignation, if not the mass termination, one or two employee can also always be fired, and that's not a legal matter also. That's not a big legal matter also. In this scenario, what will happen that if there is arbitration, party will always be at loss. Right? In this scenario, there is conciliation where parties, if let's say employer is not agreeing to certain thing, he won't sign the award. If employer is not agreeing to certain thing, he won't sign the award. Right? If both the party agree to certain scenario, they will sign the award. Right? This award, when they sign it, become binding upon themselves. They don't have to go to the court. Do you get it? They don't have to go to the court. The award, which will itself become binding upon them. Right? Do you now
Yes,
get the
sir.
difference between arbitration, conciliation, and mediation?
Yes, sir.
Perfect. Everyone, what about you?
Sir, can you repeat once it, I mean, very simple way? So, I mean, mediation and cancellation.
Sure, 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 sure. Let me start this way. See, arbitration is the all three are the process of resolution of dispute only. Whereas in arbitration, you are resolving a dispute between two big parties, where uh, the resolver, like he is arbitrator, and in arbitration, the award is pronounced by arbitrator based on the merit of the case. Right.
Correct.
In mediation, obviously, mediator help and negotiate the case, bargain the case, but the award will be signed by, it's called settlement agreement, and the settlement agreement will be signed by parties only. Now, signing of the settlement agreement itself does not make the settlement agreement binding upon the party. They have to visit the court and they have to get an order from the court. There is different process to get an order from the court. There is entire different setup for getting an order from the court. But yes, they can do so, and that will, shorten the period of time that the party were devoting in the court.
Mhm.
Let's say if you file a regular case, it will take some 10, 15 years. So mediation, it will take less than 1 year. This can be done, but there will be a time that will be wasted in mediation.
Mhm.
Now, since the award is passed by the court, it will be executed by court. Now, in conciliation, what is happening is that conciliation is also a process where you are resolving a dispute. But one thing that changes scenario is that when the parties are signing the conciliation agreement, it itself become binding upon both of them.
Mhm. Mhm.
Right?
Once
They
it
don't have to visit the court, which
they
means
got
that
it
even
also.
this 1 year that is or 2 year that is being invested in the court, we are saving that time.
Mhm. Mhm. Okay.
Right? So there can be several process of conciliation. There can be like the company, the big setup, let's say 5,000 employee or 1 lakh employee. The setup is huge, right? So there can be number of conciliation orders given by conciliator itself within the company itself. They don't have to go to the court and it will become binding upon itself. I mean, they see the company and the employer doesn't have to go to the court to and fro.
Mhm.
It's
Mhm.
not only saving the time of the parties, but the process is also saving the time of the precious time of the court,
Okay. Agree, sir. Agree.
right?
Yes, sir.
Now there is one more term. I mean, this is not per se drafting matter. This is not something that you actually litigate, but you should know. Lok Adalat.
Mhm.
Right. Lok Adalat is when the parties are unable to, pay the fee of advocate. They are saying them indigent is not the right word, but that has been used in textbook and where I would say that they are not equipped with so much of resources that suppose that you are earning 10,000 a month. Would you like to invest 10, some 5, 6K in litigation? I don't think so. Right, those are the scenario of most of the Indians. Approx 80% of Indians are earning less than 30,000 per month. Right. So those are the scenario, and most of court is trying to strengthen the bond of local adat so much so that most of the Indians are covered under this local adat scenario. Now, not all the cases can be the matter of local adat because whatever order is passed by first of all, this is the presiding officer, what you call conciliator, what you call arbitrator in arbitration. The person acting in Lok Adalat will call presiding officer. Now, instead of the party signing the award, here presiding officer signs the award, and this award cannot be appealed. Right? This award cannot be appealed. It has to be a small matter, petty matters, uh, only cognizable cases, only small and petty matters cases are the matter of local.
Okay, sir. One question, sir. So, if arbitrator decides, I mean, based on merits, so after that, any one of the party, they are not going to attend Lok Adalat as well as court, right, sir?
See, you cannot file. That is called. Um, See, you cannot use multiple medium for
Mhm.
same case.
Mhm. Okay. Okay. Sir, if if for example, leave it arbitrator case. So, if one of the case related to any diverse cases, so I attend local adalat. So I agreed both the parties in the diverse case. So after that, can I challenge that? I mean, award into any court, sir?
Award into any court. See, even if you agree both the parties to go for divorce, as I
Mhm.
said that you cannot command the court, right?
Mhm.
Court will use its own mind. Court will apply its own mind to resolve the case, which will be on the merit. However, they will consider your settlement agreement, but they are not bound by it. Right. So divorce, culture of law is that it doesn't, actually promote divorce.
Okay.
Even if you agree with parties, both the parties to go for divorce, court will cross question and try to examine whether, because there is lots of rights and violation in the case where two couples are going for divorce. So in that case, court will take that into cognizance and will try to solve the matter as amicably as possible. In the end, maybe court may grant divorce, but still, court will apply their mind. Again, this is not the part of drafting, but you wanted to know, I say.
Yes. Yes. Thank you, sir. Thank you.
Like now, since we now know that difference between arbitration, conciliation, mediation, Lok Adalat, and litigation, we also know about arbitration agreement, and we also know that what are the international parties, what are the national parties. It has become important for us to talk about the process of appointment of arbitrators, and moreover, more so, we will be also talking about how an arbitration proceedings are actually commenced, right? So, how it is going to happen? See, first of all, the arbitrator can only be in odd numbers, which means 1, 3, 5, 7, 9, and so on, continue until infinity. But you, this is the practical scenario that a party cannot afford more than 5 arbitrators, or let's say 9 arbitrators if the party is so much. Saying that, what I want to say that the minimum charge that the arbitrator makes is 4 lakhs per case, and average charge that is seen nowadays is 18 lakhs per case. One arbitrator charges that is there in your court schedule. If we'll open court schedule or arbitration conciliation act, we'll know about the charges. That is the minimum charge that is authorized by the government. The arbitrator can ask more than this also, and it is you who can either reject it or accept it. Now, once you have appointed the arbitrator, you should know that appointment of arbitrator itself creates an arbitral tribunal. So after arbitral tribunal has been constituted, arbitral tribunal can proceed on for granting or resolving the dispute, granting an arbitral award or resolving a dispute. Right? It arbitral tribunal cannot be disqualified based on the consent or disapproval of one of the parties. It has to be disapproval of both of the parties in the second court. Now, see, there one or three arbitrators that doesn't change up the fact. There will be a bench, right? The advocates and the party will always refer to the bench and not to the individual arbitrator or arbitrators, right? So, in the civil case, you see that you need to present a plaint, and then the party has to give written statement, and they can later on go ahead and file for this counterclaim set off, right? Later on, they can do so. There'll be examination of the document, there'll be examination of the plaint, and once the examination is completed, thereafter, the plaint will be admitted and the first hearing of the case will start. This is the normal proceeding of civil court. Now, when you talk about arbitration, within 30 days of filing, constitution of arbitral tribunal, the plaint has to be submitted, and within 90 days of submission of the plaint, statement has to be submitted. This goes the same in the court itself. What makes up a big difference is that when you are submitting the plaint, you have to submit all the evidences, all the documents, and each and everything that is supporting your case with the time you are presenting a plaint. This is why this is to save the time, right? Our tribunal has 6 months of time to talk about the plaint and written statement. Thereafter it will start the proceeding. Not more than 6 months. Now, within these 6 months, our tribunal can also pronounce the award itself. Like, it's not necessary to go for oral argument. Both the parties, if they agree, they can go for written argument itself. Like whatever there is in the plaint, they will go with that, and whatever there is, whatever evidence has been presented, Based on that they'll be giving the award. Now, with the presentation of written statement, or with the submission of written statement, the parties has to present counterclaim if there is any, or set off if there is any, with the written statement itself. They don't have to wait for any more days. This is done to save the time. Now there are two kinds of proceedings in the arbitration itself. One is regular that you are seeing. One is fast track arbitration. Fast track arbitration has to be concluded within this 6 months will be the conclusion of the arbitration. Right. So hereafter, you can in the fast track arbitration, normal oral hearing is not allowed unless and until both the party asks for it. Right. Now, once the proceeding and presentation of plaint and statement and or presentation of evidences are complete, parties will be asked to settle their case, and either they can use Section 30 of Arbitration and Conciliation Act to settle their case through settlement agreement signed by both the parties, and thereafter it will be signed by arbitrator, or the arbitrator will pronounce the award based on Section 31 of Arbitration and Conciliation Act. Once Section 31 is active and arbitral tribunal has pronounced the award of this section, the same cannot be set aside unless and until the interference of district court. So you see very formal procedure in arbitration, very formal. There are strict guidelines which to be followed. There is strict time schedule which to be followed, right? And if you miss on it, there will be unilateral arbitration. What is unilateral arbitration? Unilateral arbitration is arbitration where you are fighting the case by yourself. There is no opposite party. Why there is not opposite party? Because opposite party is, after signing the arbitration agreement, they are not coming in the court. Right. Last class, some of you have asked that what if the party has signed the arbitration agreement and is not coming in the court or not coming in the arbitral tribunal? What will happen? The thing that is going to happen is that you can fight your case yourself, and based on all the evidences that is there, the arbitral tribunal pronounce the award. Right? Do you get it?
Sir, so the procedures are to be followed based on CPC.
Based on arbitration conciliation act. CPC is not active in arbitration conciliation.
Okay.
Right. This is just a brief idea about arbitration. I won't say this is the complete class. Right. Brief idea why, so that you may decide that what recommendation are you to give your parties, and how to draft a case, because unless and until you have an idea, see, I could have explained you arbitration agreement, that's it. But I thought that giving you an idea so much so that you may actually draft your, arbitration agreement and all. Right. Let me know if there is any questions.
So on Friday you told us to submit the assignment, but we didn't get that.
Yes, yes. The team has told me that in the last of the days, when entire course will complete, then we'll give you assignment and you can choose on which assignment you want to work. Based on that, you will be submitting your assignment, and we'll give you certain time to work on it, and we'll check your assignment and reply back.
Okay, sir.
After completion of the course, we'll get an assignment. All right, I believe that there is no question. If there is any question, please ask.
So as we know, that any person can be appointed as an arbitrator, but
Come again.
as we know that anyone can be appointed as an arbitrator, but how much I have understood that it's a big deal, like arbitration and all, with domestic and international. So, would it be an injustice if we appoint anyone as an arbitrator, or is it
See,
criteria
earlier,
that
earlier there was recommendation that following person like judges, advocate with more than 10 years of experience, scientists with more than say 10 years of experience, and so can be arbitrators. But that was removed. Why? Because that way a common person will have no access to arbitration. So that was removed. Now the thing is that let's say I run a semiconductor company, right? So I have this much of diligence that which who will be who can properly judge my case. I have that much of intelligence in me that if I am to choose my arbitrator, I'll do accordingly. There should be no compulsion and there should be no guidelines. So that is how it is working. That there is no guidelines, but my intelligence will respond to that. I cannot actually keep anyone as arbitrator. Do you understand it?
yes? And so, how far the judicial intervention is restricted under the arbitration
See,
conciliation?
judiciary. This has become a very foreground of judiciary, interference. Now and then, from the scholars, from high judges, there has been, saying that there shall not be more judicial intervention in the matter of arbitration. But judiciary do interfere in the matter of arbitration because Supreme Court has Article 141 and ultimately it is to command entire matter if it is of any adjudication. Right. So judicial interference is there, and that is how n number of case laws is there in arbitration. Sayog Engineering, Balco, Patel Engineering, NHI case. There are several cases in arbitration. Likewise, constitutional and any other subject. Right. Reason behind that is that there is judicial interference. That is why the number of cases is rising up and becoming a landmark judgment. Right. Second thing is that if if we eradicate or eliminate judicial intervention, then we won't be able to see justice as it is because it is judiciary who is actually playing the common ground of between the parties. Let's say one party is the government, other party are the common people. Because in the matter of like NHI, National Highway Authority of India. So in NHI, one party is central government, other party is farmer. So in this case, what happens that they gonna acquire the land and farmers can't do anything because for the farmers or people like that, it is very difficult to understand the common procedure of the court. Now, arbitration is, I mean, see, we are discussing for the first time, right? So it is very near to impossible for farmers or lower middle class to discuss or understand the lengthy procedure of arbitration. Right? So for in these matter or any matter that goes beyond the scope of justice, interference of judiciary is granted and appreciated also.
Yes. And so, can a foreign seated interim award be enforced in India?
Come again?
Can a foreign seated interim award be enforced in India?
Yes, yes, obviously foreign award can be enforced and likewise our award can also be enforced in US. Unlike the Trump, whatever Trump says doesn't no don't mind him. If there is an award passed by Indian arbitral tribunal, it will be enforced in USA also. One cannot
If,
break the treaty, no. And if one has to break the treaty, that will be a lengthy and huge process setbacks. Because in international law, you know that there is no law in international law. All entire thing depends upon the consent of the nation, right? So it's a very difficult ground and it's a very interesting ground as well. Even after studying entire law, even after studying 5 year or 10 year of law, when you try to litigate a foreign case, it'll be you'll have to start from the very beginning. That's the challenge and that's the beauty also.
Sir, can I say?
Yes, yes, please.
So, previous class, I asked you one question, sir. So, how will get a arbitration? So, you said like arbitration bar of India is there in Delhi. So, they are going to give us permission to us to set up a arbitration. So, they mentioned guidelines like so if you need to set up a arbitration, then we need to have, I mean, in law profession at least 15 years of experience, or else you need to be a retired judge. These things they mentioned, right, sir? And so based on that, we will get a arbitration. And for example, for tribunal purpose as well, so the High Court and Supreme Court, they are given a permission to establish tribunals. So now, what is the difference between arbitrator and tribunals? So
See,
specifically,
arbitrator, we have discussed now and then that what you see in court, what you call them judge in the court, you call them arbitrator in arbitration.
hmm,
Now, our tribunal, once you choose this, what you call bench, no?
hmm, hmm.
Right? One judge bench, two judge bench,
Yeah,
three judge
yeah,
bench, five judge bench. What you
yeah.
call bench in the regular court, you call tribunal in arbitration. So likewise, you can relate, no?
But in tribunals, so they don't have specific knowledge in law side, sir. If, for example, if
That's not
any
required.
English,
That's not required in arbitration also.
okay, but
It is
arbitration,
upon the parties to choose. See, if the both the party agree that okay, we need someone from law background. As I have given you the example, let's say I've opened a semiconductor company. So why would I need a law person to in my case because this is a semiconductor company.
yeah,
Maybe
in
I
that
need some
case,
scientists or so.
agree, sir. In that case, so whoever having a more knowledge on semiconductor, so for
That will
example,
yeah.
I'm a chief engineer in that. So I have a more knowledge in semiconductor side. Okay. So if any issue comes on semiconductor industry, so I will become a, I mean, like
You can
uh,
become an arbitrator.
arbitrator. So in the tribunal case as well, so I have a knowledge. I don't have knowledge in law side, but I have a knowledge in semiconductor side. So I will become a tribunal as well. So then one a skilled person can become a arbitrator. Skilled person can become a tribunal. So now,
See,
what is the
tribunal is a seat like you call bench. Right? Bench is not a person.
Mhm,
Right?
mhm,
Bench is what? Bench is a recognition of a person that is sitting over there as a judge. Likewise, tribunal is a recognition of a bench that is sitting over there as an arbitrator. So,
mhm,
saying tribunal, yes, I have a query from Sneha and Kumar Swami. Kindly wait. I have addressed that. Uh, all right. Tribunal is basically what you call bench in the court, right?
mhm,
What you actually want to talk about is arbitral institution. Right? Arbitral institution is what we take authority from Government of India and Supreme Court and High Court to create in a district or national level. Right. For that, you need certain qualified person from different backgrounds to start your own arbitral institution.
mhm,
Usually, big law firms, if you have a law firm which is active throughout India, right, it's easy for you to get a recognition of arbitral institution. Now, the benefit that arbitral institution will get, let's say, I'm a person with 200 crore of business at least. Right. So, in my case, I'm looking for someone to arbitrate, some institution to take my arbitration work. Entire proceeding will be handled by arbitral institution. Whatever will be the award or judgment, I'll follow that.
mhm,
Right. So, for that purpose, I have nothing to worry about. I don't have to appoint the arbitrator. I don't have to, construct the. I look for the arbitrator, look for the place where arbitration will be constituted, and so on and so forth. Entire headache will be taken by arbitral institution, and I just have to sit and relax, wait for the award, and then if I'm to oppose this award, I'll go forward or I'll execute it. Now, Sneha is, I think we have solved your query, right? Now, Sneha, I've asked the question that what is difference between venue and seat of arbitration? See, Sneha, venue means that let's say you are in India and you want your seat of arbitration to be in Switzerland. So that can happen. Seat of arbitration means that you will be abide by jurisdiction of following case, right? And the venue is where you are actually conducting the arbitration, where your arbitrators are coming, where your parties are sitting, and like that. Whereas seat of arbitration means that, let's say Delhi is my seat of arbitration. So I am to be bound by law of India, and if am to oppose the award, I'll visit district court of Delhi, maybe Tisajari or so and so, Saket and so and so. So whatever is the place of my arbitration will decide the court that I'll visit. And venue is the place. Venue can be online as well. I am in India. Someone there is in Switzerland. Someone is in USA. So venue is online virtual forum, right? Where we are discussing the award, where we are solving the dispute, but it has nothing to do with jurisdiction of the case. Yes, Kumar Swami, please ask.
Sir, as per my knowledge, tribunal is public in nature, it is time consuming and is formal in nature.
No, no, you're talking about regular tribunal. This is arbitral tribunal. Arbitral tribunal is different than regular tribunal.
So, okay. So, arbitral
Right?
tribunal
You're
is there and
talking about,
arbitral
let's
tribunal.
say, you're talking about tribunal which you call service matter tribunal, green tribunal, right? You know,
Yes, sir.
energy tribunal. So
Yes, sir.
those are different tribunals. This Nidari was specifically was discussing about arbitral tribunal.
So, arbitrary is different and arbitral tribunal is different, is it?
Arbitral tribunal is different than the regular tribunal.
Okay, sir. Okay,
There's a
thank you.
huge difference. This was really interesting class. If people have asked a number of questions, and that has looked me with interest, and that has also challenged me to answer your question, and I liked it. Right, I'd like to see you in next session, or maybe a next entire subject whenever it will launch. Best wishes. If you have any questions, please come. Please ask. Otherwise, we'll be closing this session.
Sir, arbitrator can able to, I mean, they can chargeable, sir. I mean, how can they get a,
Yes,
I
yes,
mean,
yes. Schedule 5. Read Schedule 5 of Arbitration Conciliation Act. Schedule 4, sorry.
mhm.
Schedule 4 of Arbitration Conciliation Act. You will get an idea that what are the charges that arbitrator makes.
Okay, okay.
Which
Thank
is,
you,
it
thank
is
you.
basically, it's not, like you see 1,50,000 to disease, 2 lakh to disease. It's not like that. It is based upon the money that is involved in the case. And based on that, the fee of the arbitrator is decided. So, if you read Schedule 4, that will become clear.
Thank you, sir. Thank you very much, and
That's good
sharing
enough
all the
money.
information to us,
That's
sir.
good enough money.
Yeah, yeah. Thank you, sir. And can you share us your LinkedIn as well, sir, in the chat, or else?
LinkedIn, yeah. You'll search Amaresh Patel, AMARESSPATEL.
Okay.
Right. I'm sending the message. Right. You'll get a profile, and that's me.
Mhm. Thank you, sir. Thank you very much.
Thank you. Anyone have any
Sir,
questions? Yes.
sir, I have a question, sir. Which arbitral clause is oftenly violated by the ex party, or like which doesn't agree to the agreement, like after committing to the settlement agreements? Like, what is the main clause of the arbitration, or in arbitration drafting, which we should keep in mind, should be, less to make it less riskier?
All right. See, first thing that is regularly violated that I have seen, that place and seat of arbitration. Sometime when we copy or lodge then nowadays when they copy and make a draft, they don't understand the difference between venue of arbitration and seat of arbitration. Right? So that makes the scenario complex. Let's say I understand the difference between venue and seat of arbitration. I have to Kolkata as my venue of arbitration and Switzerland as my seat of arbitration. So it's easy for me to let's say I have a 2,000 crore of business, so it's easy for me to get an advocate in Switzerland. But it's not easy for other party, right? So this, I mean, arbitration is the game of money, right? So if you won't be able to challenge the award due to lack of money, how it would be, because other parties know that if let's say the award will come against him, he'll challenge in Switzerland. If it is in favor of him, he will just execute it. But for you, it would be very difficult because you won't be able to do that. Right? It would be in game for you. So that is very dangerous clause. Second most dangerous clause is Section 4 of Arbitration Conciliation Act, which talks about unilateral arbitration. Like, in unilateral arbitration, what happens that other party is not entirely in the case. In regular court, let's say in civil court, what happens that the award will come against me. I'll file appeal of it in the higher court, and then the scenario will become more about the same. Right? This is what happens in civil court. In civil court, generally people don't go in the court. Let the ex parte award come, and then I will challenge in the higher. This is the attitude of nowadays people, that I won't be fighting this case for 20 long years. Let him file his case, and then after 20 years, maybe if he'll survive, I'll see in the higher court. But same is not here in the arbitration. In 1 year or maximum 18 months, case is going to be concluded. And after this 18 months, you cannot appeal this judgment that been passed by arbitral award. You cannot appeal it. You can only set aside it. And if reason for setting aside is very narrow in section 34, you see. In section 34, you see there is very narrow reason. And if you won't be able to do or make an argument about that or persuade the bench about that, you won't be able to actually challenge it, and that will cripple your entire journey of maybe business or maybe life. Not life, because this is not a criminal matter, but business obviously. Let's say 200 or 2 crore is the penalty, and I have a company worth 4 crore, 2 crore is the penalty. So where I am going to survive?
So what about in online dispute resolution? Like it's very prompt in India nowadays. Like people are
Online dispute resolution is the best practice that the world can see now. Why I tell you? Because first of all, it's saving time. Not only that, lots of uh, you know irregular involvement of money are saved. Let's say common person has to, let's say advocate, talk about advocate itself, or anyone, you are saving huge amount of money of the court, of the party, and likewise, right? You don't have to charge the parties for the coffee that you drink. That's upon you. You don't have to charge advocate for the trouble they make. Let's say the person is from Bangalore and he has to travel Delhi all the way. Like, so it is gonna cost huge. And train is not a journey that we can make in India. Flight is the only alternative that we have. So the to and fro flight, that will be huge charge on the advocate and the client itself. In the online, I have written a paper also on this matter and had been published in Scopus by Journal of UK International Journal of Law and Management. That you will see online dispute resolution. Amaresh Patel, if you search on internet, you will get it. So mm, I'll say that I have a good analogy of it in that paper. You can go through that if you like. Also,
okay.
I
So
have
sir,
shared my
please send the link for that paper, or could you, if you just
just type online dispute resolution paper Amaresh Patel. You'll get it.
okay, sure. Thank you, sir.
Right. I have also shared my LinkedIn profile. Right. You can all my papers are also available on this LinkedIn profile. So
Sure,
you
sir.
can
I'll
also, yeah, several notes are there. I keep on updating notes, and you can visit the LinkedIn profile and be updated. Like, anyone have any further question? So thank you again for the time and for discussion. It was worthy, and maybe I look forward to next session soon. Thank you.
Thank you, sir. Thank you very much.
Thank you, sir.